Well, I think in the interest of time, we should probably start the session. Uh, as I think was made clear by Sir Paul Marshall this morning, we've had another number of government ministers who've not able to be with us today because of Purdah. Lord Bridges, unfortunately, is one of them. And since this was going to be a fireside chat with Lord Bridges, that would be rather a lonely exercise for me, since he's not here. But I've managed to find an excellent pinch hitter in Martin Howe, QC. And what we're going to do instead in this programme is I'm going to talk about the EU negotiation and the EU free trade agreement a little bit, and then we're going to talk about the nationalisation of EU law, and Martin's going to focus a little bit on that process. It is no coincidence that we are doing this panel at this time in the day. I think we have a tendency to look at everything that is happening in Brexit solely through the lens of the EU negotiation. As we've tried to make clear in the course of the day, that is just one part of one pillar of a overall trade strategy for the UK. Now, it's a very important part, and we're not downplaying the significance of it. But I think it's important to understand how it fits into the rest of the process, because it has the capacity to have significant effects on the rest of the process in both a negative and also, frankly, in a positive way. So where are we now? We've triggered Article 50. We are in the negotiations with the European Union, which will obviously include two agreements, a withdrawal agreement and an agreement of some kind on our future relationship. And David Davis made it very clear that that is aimed at a comprehensive, deep and special free trade agreement. And I think he described it in a way that I would agree. I would describe it as the potential, at least, for the most comprehensive free trade agreement that exists because of the integrated nature of our supply chains. Now, it is very unlikely that we will have that comprehensive agreement within 2 years of now, certainly by March of 2019. So we will need to leave the European Union with some interim measures. And if you recall, those of you who were in our earlier sessions, the way you craft what those interim measures are is not to say, oh, we need a transitional arrangement to cover everything. What you say is, here's where we are in our negotiations with the EU, here's where we are in our negotiations with and our discussions with other people. What do we need to do to minimize as best we can the disruptions as a result of coming out of the customs union and coming out of the EEA? So on the customs union, we are going to need things like a zero for zero tariff deal between the UK and the EU, which is fully WTO compatible. Mutual recognition agreements on standards and product regulation, which again is going to should be relatively easy to do because we have ported over all European regulation and technical standards. A zero for zero deal means that we have to have rules of origin, because everyone will be concerned about products coming from outside of the combined UK-EU region. That piece of it is going to be a complex negotiation. Sadly, rules of origin negotiations are always complex negotiations. And Britain will take a pretty open view of that. I mean, we all want to accumulate, which means that we want products coming in supply chains across lots of countries, and we want to be able to export those products into the European Union. The EU may have a different view. And then customs clearance. We're allowed, again, under WTO rules on interim measures to have expedited customs clearance measures. But frankly, we already do have expedited customs clearance between the UK and the member states of the European Union, who all do extremely well and are highly ranked on the WTO, on the World Bank's list of customs clearance measures. But we have lots of examples of very good customs clearance that are not in customs unions. The best one being the the US-Canada relationship, where you have $1.5 billion worth of trade every day that is cleared through automated customs, through authorized economic operator programs, etc., trusted trader programs. We will have to have our own authorised economic operator programme in the UK. We should be developing that now. HMRC should be going to businesses and going around the country and explaining what it's going to look like. And that will have to be mutually recognised by the European Union. And again, the EU has 26 MRAs with authorised economic operators, programs from other countries. No reason to suppose, and there may even be a WTO case if we have a situation where we are not allowed to have an MRA in that way. And again, European businesses also will want mutual recognition agreements in that area. So on the customs union, those are the things that we would need to have. On the single market, coming out of the single market presents issues that you discussed this morning in financial services. I would commend a paper that we just produced on financial services, essentially saying what you want is a mutual recognition type arrangement. So you will want prudential, essentially you want home state recognition, supervision, acceptance across the UK and the EU, provided you are doing things that are reasonably necessary for prudential reasons, and you're not doing things that are anti-competitive. So clearly, if the UK were to try to be a casino, that would not cover the prudential qualification there. But at the same time, if one or other party is moving in a very anti-competitive direction with a lot of regulatory burdens that are not necessary for prudential reasons, there would be some sanction there as well. This is why it's very important in all of these arrangements, not only to manage the divergence and recognize that standards, we can have divergence, and divergence is a good thing in some ways, but also to move both systems towards a more pro-competitive regulatory system. Actually, the UK financial institutions are very good at in Basel and in global institutions arguing for pro-competitive standards. That lobbying needs to not stop at the door of the global institutions, but needs to continue into our EU negotiations. And then we have digital single market, aviation, and so on. So there's a whole series of interim measures. And we will have, at the end of 2 years, a basket of those interim measures in anticipation of this comprehensive free trade agreement. How well covered that basket is going to be the result of a negotiation, and we can't, second guess that negotiation. There is an important aspect to this of sequencing, and we talked a lot this morning about regulatory issues, standards, product regulation. Why do we want to have? Why don't we just harmonise everything with the EU and be done with it? What's the reason not to do that? The reason not to do that is nothing to do with what business wants, actually, because businesses, in my experience, having represented them for 25 years, in my experiences, businesses are very good at saying that, well, we just want harmonisation. We just don't want any divergence. And that is a relatively good position as long as the regulatory arrangements around which you don't want divergence are consumer welfare enhancing and are pro-competitive and actually grow the market. And it is the consumer voice here that is very, very important. And therefore, our chief trade negotiator at the moment, Theresa May, whoever it will be after this election process, is negotiating not just for UK business, they're negotiating for UK consumers. And they're negotiating for users, and every business is a consumer of something. So it's a case of the pro-competitive regulation is an incredibly important goal to have, and you don't accomplish it simply by saying the goal is harmonisation. So the problem of locking into regulatory systems in Europe, because that's where we will be pushed, unless I think there are simultaneous negotiations with other countries. That is something we're going to have to think very seriously about. The other issue in terms of sequencing is, if I were advising the EU, I would not necessarily want to have a two-phased approach to this, because actually it is in the WTO rectification process that we talked about this morning that a lot of the financial piece for the EU may actually come, because however you do this, the EU, in the rectification of the UK's tariff schedules and so on, the EU may lose out and may have to do things that cause harm to other countries, in which case they will be sued in the WTO. And the ability of the EU to be able to say to the UK, you know, you should pay for some of this, is important. And therefore, if you simply do the financial stuff first and then wait, you lose all of that. You also don't know, if you do that, how much you should be asking for, how much the EU should be asking for from the UK, because we are going to be using, for both the interim measures and the ultimate arrangements, we are going to be using European infrastructure for mutual recognition in some ways, and we ought to pay for that. The rules on pay for should make sense, should make economic sense. If we are actually doing something that causes harm to the European Union, then it is perfectly reasonable for us to for them to ask us to pay for that. But you can't do any of this if you say you're going to do the financial piece first, totally separate, and then you're going to do the rest of it. That approach actually helps the UK. I mean, so I was a bit mystified by that approach, particularly from the European Parliament. One of the other things that we are going to have to do, and this is where I want to bring Martin into this, is as part of this exercise, we are obviously going to nationalise over a lot of, perhaps not exactly all, of European laws, directives, regulations, European court decisions as a matter of English law. And we're doing that for technical reasons. So that creates a baseline for a negotiation with anyone else we want to have a negotiation with, including, of course, the EU itself. But that is a soft baseline. It's a soft baseline because we're not wedded to that regulatory system. We're doing this for technical reasons. But in some areas, we may want to keep that baseline. And it does represent something that can be traded in the context of other trading arrangements. But that process implicates two things. One, it implicates our own economy, and in terms of the unilateral pillar of our trade policy, those of you who heard us describe that this morning, how we can improve our own economy, have more pro-competitive regulation, that pillar is implicated by the porting over process. And it also, critically, will have a huge impact, if not handled properly, on our relationships with other countries and our negotiations with other countries. So on that note, I'm going to turn over to Martin and ask him to talk about the nationalisation of the EU, of the acquis, that process, how you see that going forward, and what are the opportunities and what should we be thinking of as we go forward in this process.
Right, well, let's turn now to domestic law and what happens to the laws of the United Kingdom. Obviously, we've been looking at external trade, but we're now looking domestically. What happens to the laws of the United Kingdom when we leave the European Union? Now, if nothing were done at all, in theory, if Parliament did not legislate, then big chunks of existing law, which at the moment are European directly applicable or directly effective laws, would disappear. This would have potentially serious consequences. For example, almost all of the law on the regulation of medicines is now based on European regulations and directives. And if we lost the European regulations overnight, it would leave a huge hole in our law. And, you know, patients wouldn't get the drugs they need for their life and health overnight. Since there are so many areas of law, the government in its white paper, which comes with a rather fetching sky blue cover, as it happens, a white paper with its sky blue, is proposing a bill that would effectively port across directly. It would do two things. One is it would keep in force European-based laws where they have been transposed, using the technical jargon, onto our statute book already. These would stay in force, and directly effective European Union regulations would be converted on the day of exit into UK laws. They would then be subject to being repealed or amended, as it were, comparatively at leisure by Parliament as we go forward. But the idea is that there should not be a big discontinuity on the 30th of March 2019. Now, there are some problems with this. One is that, that they are intending to import not just the regulations themselves, but also the the decisions of the European Court and general underlying principles of treaty law which interpret these regulations. Now, the justification for that, which makes sense in its own terms, is that if they didn't do that, then the meaning of these European laws would change, and they want to keep them the same. However, they make an exception in one case to one particular bit of basic treaty law, which is the European Union Charter of Fundamental Rights. And I think politically it's probably a bridge too far to incorporate that into domestic UK law, leaving our judges free to play with it and expand it for the next 20 years, a nice plaything for the judicial activism of the courts. So they're not going to incorporate that. But apart from that, this is the general plan. However, there is an important qualification, or rather two important qualifications they make in the white paper. It's not as simple as that. In some areas, it is quite simple because you have a freestanding law which can simply be kept in force, and it will operate the same way after exit as before. And there's a lot of, for example, workers' rights laws in this category. But in many instances, EU law or EU-derived law is dependent upon the operations of supranational bodies, and it cannot continue to operate after exit without the continued cooperation and involvement of those bodies. So decisions need to be taken on what to do instead. And at a broad level, one could say, well, if a European Union supranational body has a function, one can find maybe an equivalent UK body or an equivalent UK court which will take over that function. But it's more complicated than that, as I'll explain. Now, that there are two, I think, very self-evident points, or they're blindingly self-evident as far as I can see, and I hope everyone else can appreciate them. One is that this process has to take place on the assumption, working assumption, that there will be no deal with the European Union. They cannot afford to get themselves into a position where the law goes into chaos on the 30th of March 2019 because a deal isn't done, or a deal appears to be done but then is not ratified by Wallonia at the last minute or whatever. So they have to have the law prepared for a no-deal scenario. So the solutions preferably avoid involvement of European Union bodies. Secondly, and this is deals with the negotiations, although in lots of areas it would be possible to say, oh, wouldn't it be nice to negotiate a special deal under which we stay involved with a particular European Union body, even though we've left our membership. Of course, every time you do that, you're then adding to the list of demands and requests in the negotiations with the EU. You're adding to the complexity of these negotiations, which in any way are time-challenged. And therefore, there is a premium on solutions which do not involve this. And let me illustrate this. The third point, very important point, which Shankar has already alluded to, is if we get into a situation where we involve European Union institutions in continuing to have a role after Brexit in particular sectors, we have to be extremely careful that we do not create a lock-in. And I'll explain that with an example. Now, let me give a couple of examples, because these points are difficult to understand at a very general level. But let's take, for example, an area I know well, which is the system of trademark protection. Now, at the moment, in this country, there are actually two parallel systems of trademark protection. You can register trademarks as national UK trademarks at the UK Patent Office, Intellectual Property Office, or you can register trademarks as European Union trademarks at the European Union Intellectual Property Office in Alicante. And many companies actually have both kinds of trademarks. Now, do we need, the difference is that a European Union trademark takes effect over the whole European Union. Could we stay in that system of European Union trademarks after we leave? The answer is we couldn't stay in it without some special deal. That special deal would be extremely difficult and also undesirable, given the political objective of escaping from the jurisdiction of the European Court. Because obviously the whole system is an integrated system under which courts of other member states have jurisdiction to invalidate trademarks or to grant injunctions which extend to this country, and the whole system's under the control of the Court of Justice in Luxembourg. And if we were to buy into that system, we then freeze our trademark law for the indefinite future. Now, we don't need to do that. It's fairly straightforward in that particular case. We simply get rid of European Union trademarks from our law, but we give owners of European Union trademarks the right to convert them into national UK marks on the date of exit, so that the businesses who have trademark coverage in this country by virtue of an EU mark don't have a justifiable claim that they've been deprived of their property. So you know, there's a solution that one can see, and there's no, as I see it, there's no need or no particular desirability to start negotiating with the European Union on any of that stuff. Then let's look at drugs approvals. Much more complex system where we've got the European Medicines Agency. Now there is actually, I think, a stronger argument for post-exit involvement in the European Medicines Agency if that were to be negotiated. But we have to be very careful if we do that. And I've looked quite closely, interestingly, at Swiss drugs regulatory law, because they're a country with a very strong pharmaceutical industry, which is not an EU member state. And while we're an EU member, we're completely hog-tied to the European Union regulatory system. Switzerland, interestingly, has a system where they can give effective recognition to the approval of medicines by the US FDA or by the European Medicines Agency or European member state or by the Canadian Medicines Agency or so on. So they have a flexible system that allows them to, if you like, give credit where drugs have been approved as safe and efficacious in a number of, by a number of reputable agencies around the world. So, you know, if we go down that road, I think we very much want to have an open system rather than a closed system that hog-ties us to the European Union and would then be potentially a big obstacle in supposing we wanted to do a deal with non-EU countries which involve mutual recognition of approved medicines as one of their elements. Now, then, there's another aspect, and I'll finish this one off, another very big area where it's inappropriate simply to continue European Union law in force. Now, the White Paper recognises the existence of this category. I'm not sure it recognises the full scale and extent, and that is areas of law which depend upon some mutual recognition system or which provide special status to European Union countries as compared with other countries. And I'm going to give an example of this, again, in the trademark intellectual property field, because it allows me to explain the point. And this is sounds like a very arcane issue called community-wide exhaustion of rights. Let me explain that with a very well-known case called Levi's and Tesco. Tesco found that Levi jeans, that is genuine Levi jeans, bearing the trademark Levi, but genuine, were on the market in North America for cheaper prices than they were available in this country. So they bought them up and flogged them off through Tesco stores. The Levi's then brought a trademark infringement action saying that's an infringement of our trademark, which says, well, they're genuine, you know, not counterfeits or anything. What's more genuine than Levi jeans from the good old USA? But the European court said, oh, no. The trademark owner has the right to control the placing of the goods inside the single market using his mark. So we effectively, the United Kingdom was ordered by the Luxembourg court to prohibit, at the behest of Levi's, the importation of these jeans from the USA. Now, this is an enormously significant economic issue. I mean, I do a lot of work in this field. I'm not an economist, so I can't give you statistics. But what I do know is that the margins between branded good prices inside the European Union and outside are sufficient to pay my fees. Whether I'm acting for a trademark owner trying to prevent the importation, or on the other side trying to find a way to permit it. It would simply be, and this is a non-tariff barrier. And you can argue about tariffs and whether they're good to protect industries, but this particular non-tariff barrier doesn't even protect domestic industry. It protects multinational companies who want to be able to charge differential prices under which they mulch the British consumer more than in other markets. And it strikes me it would be madness to continue that. That's a decision that needs to be taken on Brexit Day. Madness for domestic reasons. Why should we carry on allowing our consumers to be fleeced for no coherent reason that I can tell, whether economic or to do with trademark law? And also, of course, maintaining that particular discrimination in goods from different markets would potentially impinge on our negotiations of free trade agreements or other trade agreements with third countries. So perhaps this is a very quick sort of survey. It's quite a complex area when you delve into it on this simple concept of repatriating all the European Union laws.
A couple of things. One, interim measures as we go through them. Dispute settlement. Obviously, once you have a comprehensive free trade agreement, you will have dispute settlement mechanism within the free trade agreement. But in the interim, this is one area where there's going to be a tough negotiation, because the Europeans have come out, as you would expect, and said the European Court of Justice would be the dispute settlement mechanism for the interim. I think the UK, post leaving the EU, is going to take the view that that can't be the case, and that there has to be some other dispute settlement mechanism, which could be in some of these regulatory cooperation councils we've talked about in areas like financial services and life sciences. So if you can reflect on that. There are also areas where, and you talked about trademarks, part of what you get from the community trademark is the bundle of rights that you receive. One of them is appeal up to the European Court of Justice. And obviously trademarks are over a long period of time. So there's going to be some areas where we have some ongoing jurisdiction of the European Court of Justice. And then perhaps most importantly, prioritization of those areas of European law where we wouldn't want to port them over immediately. So, for example, the most obvious things are things like the common agricultural policy, the common fisheries policy. Do you want, as a matter of English law, to nationalise European control over your territorial waters? You probably don't want to do that. And then there are another raft of European laws and regulations which are either inappropriate to the UK because they relate to the production of olive oil and we don't produce olive oil, or things like that. And then the final area would be regulations where we simply don't think we don't think they fit our economy. So then you're in areas like the Port Services Directive, which is directed towards countries that have state-owned ports that are transitioning to private ports, where we are all private. So that sequencing seems to me to be incredibly important, because some of this has to happen before the date of leaving the EU, and some of this has to be prioritised into the parliamentary calendar immediately afterwards, because the longer you wait, the more a vested interest group builds up around that regulation, and then they will fight to prevent any change.
Well, I think there are two issues there. One is this issue of transitional or interim periods. I think that's a very problematical issue, because it seems to me that there are very different kinds of interim or transitional arrangements that one could have. One could have, at one end of the scale, a tightly defined specific transitional period to allow a particular sector, to get their licenses sorted and get their trading methods operating in accordance with a new regime which is identified. And it seems to me, in that context, well, if you have to live with European Court of Justice jurisdiction in the interim, well, we've been living it for the last 40 years, and we can bear it for another 2 or something in a particular sector. But there are other transitional agreements, potential transitional agreements, which strike me as extremely dangerous. And that would be a sort of general transitional agreement extending European laws and European regulatory agency powers across our economy, because the danger of such arrangements, particularly if they're not absolutely time limited, is that they're just cop-outs. They just put everything off. The negotiations have no deadline. They just go slower, and a business is then subject to prolonged uncertainty over the regime that it will be operating under, which of course was one of the arguments the Remain side was very strongly putting out during the referendum campaign. There will be years of uncertainty while negotiations go on. So allowing us to get into transitional arrangements which have that potential would be very dangerous.
Thank you. We have time for some questions from the floor. So there's a question at the front here. If you could identify your name and affiliation, and if you can also keep questions short, that would be great.
John Cook from the City UK. I was interested by the various cases and types of problem that you enumerated. You didn't mention the devolved administrations, and when I look at the exam question behind you, how Britain can gear up for a comprehensive FTA with the EU, of course a comprehensive FTA will involve agriculture, and when there is no longer the supremacy of EU law, the devolved administrations will have certain number of areas of jurisdiction over agriculture, the environment, and a number of other things. How do you think that will be settled?
I'll give you a comment and then I'll hand over to Martin. First of all, I don't think this is that difficult a question, because right now the situation is that the devolved administrations have authority over certain things, agriculture, food, etc. policy, but that's under the construct of the European Commission, or the European Union having authority and competence to deal with trade issues. Now, once you pull that trade competence back to London or to Westminster, it is impossible for a devolved administration to then have authority over agriculture, because everything that you do in agriculture is going to have a trade component or a trade nexus. So it simply makes no sense to do that. There are other areas that the devolved administrations will have authority over, and even within agriculture there may be some very specific things that you might do. So just to give you an example of that, even this gets you pretty close to the line in terms of what is trade authority. You may have a system where you say, if I'm a farmer in the Scottish Highlands and I have contributed to a significant tourism industry as part of our direct payment structure in agriculture, we may want to, not as an agricultural payment, but as simply a payment for contributing to that tourism industry. You may want to do something like that. That could be within the authority of the devolved administration. But I will tell you that our trading partners will not take kindly to that. I mean, they will assume that that is some sort of agricultural subsidy, and they will seek to challenge it. And if the UK does not have authority over that, and it's the UK that has control of the schedules, it will not be able to respond, and that will create a problem.
I understand all that, but that's not what the devolution settlements at the moment say.
But I'll let Martin answer.
Actually, it is, and I'll explain why. It's a fundamental principle of international treaty law, including trade agreement law, that the counterparty states are not concerned with the internal legal structure. And I think the same issue arises in Canada, because there's the federal Canadian government, and then there are the provinces, or in the USA with the USA and the states. At the moment, in fact, trade agreements clearly take precedence over all law of the Scottish Parliament. And the reason they do that is Nicola Sturgeon hasn't noticed it because she loves the EU so much, but one of the clauses in the Scotland Act, and the same actually in Wales and Northern Ireland Acts, says that the Scottish Government and the Scottish Parliament must comply with European Union international obligations. And because at the moment all our trade agreements are via the EU, this effectively binds Scotland to comply with their provisions. It will be necessary as we develop freestanding trade agreements, not via the EU, to replicate that provision of the Scotland Act in respect of non-EU trade agreements. But there will no doubt be screaming and shouting from Edinburgh about this as some gross interference with their prerogatives. It will actually be nothing of the kind. It will be preserving the situation substantively as it stands.
There's a question in the back on the right side there.
Miles Salteel, Adam Smith Institute. You've spoken of the Great Repeal Bill. In today's Times, there's an article from the IEA and the Taxpayers Alliance calling for sunset clauses on the acquis represented in the Great Repeal Bill. Do you regard that as a realistic proposal? And if so, what might it do to our obligations by way of mutual recognition?
I think the problem with the sunset clause is that there's actually a huge mass of stuff, and obviously the benefit of a sunset clause is that it effectively puts government and parliament under a compulsion to go through, sort it out, clean it up. The problem with it is it's such a vast and complex area that you could easily end up with just bits of the law disappearing that you didn't expect to disappear. I'm not convinced by the merits of a sunset clause in that context. I'd be more convinced of the merits of it in a context where you are a lot of legislation will have to be done by delegated legislation, not by Parliament, in order to get it through in the time. I'm much more convinced of the merits of having a sunset clause on those pieces of legislation, which then forces them to be reviewed within say 10 years by Parliament. What it has on mutual recognition, I don't know.
Yeah, so it's on mutual recognition. It's a sequencing question depending on the timing of the ultimate trade agreement. The trade agreement itself will have mechanisms for mutual recognition. They don't have to be, by the way, part of the trade agreement. I mean, that you can have mutual recognition agreements without a trade agreement. We have 6 areas in the EU-US mutual recognition agreement of '97 that are, we don't have a trade agreement with the US. The EU doesn't have a trade agreement with the US, so you can have all those in place anyway. And the issue is how they manage this divergence. I mean, I think it's attractive to have some forcing of the parliamentary calendar, but the bigger question that the UK government has to sort of answer is what is the cost of this regulation that we are porting over, and therefore from that to develop a list of priorities for the parliamentary calendar going forward. There's one last question, which was the gentleman over there.
Thank you. Paul Hardy, DLA Piper. My question is about the role of the European Court of Justice in EU third country free trade agreements. What can you explain sort of what role it has in current EU free trade agreements?
None.
And would it have any role in a
No.
UK-EU free trade agreement?
No, it would be no free trade agreement has some court that is part of one party having jurisdiction over the trade agreement. I mean, every trade agreement has a dispute settlement mechanism, including the WTO obviously has a dispute settlement understanding that is a separate freestanding dispute settlement mechanism. It usually involves some form of arbitration between the parties. But no country would accept the dispute settlement mechanism. That the English courts, for example, I mean, if we were to do a trade negotiation with the US, and subject it to the English courts, the US we wouldn't get very far with that.
Can I add a rider to that? The European Court does and will continue to have internal jurisdiction in respect of free trade agreements. So inside the European Union legal order, the European Court does have jurisdiction to interpret external obligations of the European Union and also impose its interpretation on the member states. But that's a purely internal jurisdiction. It doesn't bind the counterparty state. I mean, for similar, I totally agree. It would be completely unheard of and absurd for the United Kingdom to accept continuing Court of Justice jurisdiction in a bilateral free trade agreement after exit. It would be completely at odds with all accepted norms of international trade agreements.
And just this point about internal competence, many countries make that decision in their own sovereign legal systems. So a lot of the countries in Latin America, for example, under civil law will simply say that the WTO system, WTO rules, are actionable in their own court. So that's a big advantage domestically, but it would never apply internationally between countries. I think we're out of time, so we're going to have to stop there. But thank you very much for coming, and thank you to Martin for stepping in.